Welcome to County Portal, your simple source for local government services and public records. Let's get started.
How long does a grand jury have to indict someone? This is a critical question in the American justice system, because an indictment is the formal accusation that kicks off a serious felony case. The answer, however, isn't a single number. It depends on a few key factors, primarily the statute of limitations and whether an arrest has already been made. The main time limit is called the statute of limitations. This is a law that sets a maximum deadline for prosecutors to file charges. If they miss this deadline, they can't charge you for that crime, ever. For most non-capital federal crimes, the general statute of limitations is 5 years. But there are many exceptions. For example, certain types of financial fraud can have longer limits, and for the most serious federal crimes, like murder or certain acts of terrorism, there is no statute of limitations at all. This means a grand jury could technically indict someone for murder 50 years after the crime was committed. State laws are completely different and vary widely across the country. In most states, a serious crime like murder has no time limit, but a crime like felony theft might have a 3, 5, or 7-year statute of limitations. You always have to look at the specific law for the specific crime in that specific state. Now, the rules change dramatically once a person is arrested. After an arrest, a new and much shorter clock starts ticking. At the federal level, this is governed by the Speedy Trial Act of 1974. This law is designed to protect a defendant's Sixth Amendment right to a speedy trial. Under this act, once a person is arrested for a federal offense, the government generally has just 30 days to get an indictment from a grand jury. If the prosecutor fails to secure an indictment within that 30-day window, the charges must be dismissed. However, it's important to know that this 30-day clock can be paused, or told, for various valid reasons, such as the defense filing pretrial motions or if there are hearings to determine a defendant's competency. States have their own versions of speedy trial rules, and they are all different. A state might require an indictment within 60 or 90 days of an arrest, while others have different timelines. The core principle is the same. Once you are arrested and your liberty is restrained, the prosecution is on a much tighter schedule. So let's quickly summarize. 1. If no arrest has been made, the deadline is the statute of limitations, which could be years away or might not exist at all. 2. If you are arrested on federal charges, the Speedy Trial Act generally gives the government 30 days to obtain a grand jury indictment. And 3. State laws have their own unique rules, so the answer will always depend on your location and the specific charges. Please remember, this information is for educational purposes and is not legal advice. If you are facing a potential indictment, you should speak with a qualified criminal defense attorney immediately. Thanks so much for watching. If this video helped you understand the process a little better, please give it a thumbs up and be sure to subscribe to our channel for more clear explanations of complex legal topics.